The Supreme Court of Florida is now in session. All have cause to plead. Draw near. Give attention. You shall be heard. God save these United States, great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. Justice Francis isn't able to be with us here this week, but she will be participating in the disposition of these cases. Our first case today is case number 20-1685, Florida Bar versus Brian Rush. Whenever you're ready.
Thank you, Your Honor. May it please the Court. My name is Brian Rush. I've been a member of the Florida Bar for 40 years. During that time, I have never been found to have been guilty of any violation of the bar rules. I served in the House of Representatives for 8 years. I was neither charged nor attacked for violations of the Florida Ethics Commission. I have 40 years of reputation as an honorable lawyer. I continue to defend myself in this case, and I would begin my argument this way, Your Honor. There are 4 standards that are relevant. De novo review of the contracts, de novo review of the rules of the Florida Bar, and the Florida Supreme Court's precedents in regard to contracts and eminent domain. The standard is clear and convincing evidence. It is our contention that there is no clear and convincing evidence to support the Bar's charges or the referee's report. Controlling Supreme Court precedents, there's 4 cases that are relevant. Wynn versus City of Cocoa is an eminent domain case. It dealt with a termination of the employment agreement, which is very similar factually. It's a 1953 or 54 case. Florida Supreme Court held that the standard is the reasonable value of an attorney's service upon termination of an eminent domain case.
Which case tells us that the standard is, as you suggest, clear and convincing evidence?
It's in the bar rules. That clear and convincing evidence is set forth in the bar rules as a standard of proof.
Which one?
By memory, I think it's 3-7.6 or 3-7.7, but it's in the rules that is in fact the standard. It's not preponderance. It's not the criminal standard. It's the intermediary standard. Those precedents, Wynn and Rosenberg, both Florida Supreme Court cases, Rosenberg 1993 or 94, again said that in a termination case, the question is, termination of employment case, the question is, what is the reasonable value of the attorney's service? Those are the exact words used in the termination clause of the Rush contract. Trial lawyers can only do their best to follow precedent. They look to precedent and they incorporate that in their agreements and their pleadings. The other 2 cases are Rowe and Quanstrom. Rowe and Quanstrom, in Rowe, the court set up a standard for awarding contingency risk multipliers and determined that the risk multiplier in a contingency case, primarily personal injury cases, would be somewhere between 1.5 and 3.0. In Quanstrom, the Florida Supreme Court said that contingency risk multiplier is not available in an eminent domain case. They are not contingency cases because of the way they are set up. And under the statute, 73.092, attorney's fees are set up in a variety of ways, but one of the ways is supplemental attorney's fees on an hourly basis. So the way the statute is set up, attorney's fees are not exactly contingent, and the Supreme Court held that because of the peculiar nature of eminent domain cases, in Quanstrom and Rowe, in Quanstrom they held that eminent domain cases were not contingent fee cases.
Eminent domain cases, your fee agreement with your client provided that fees will be paid by the Department of Transportation. However, the client will be responsible for the fees if the client terminated representation. Is that a standard clause in eminent domain cases?
Is a standard clause of lawyers in Central Florida and it arises from the peculiarities of the representation. First of all, it's not a contingency fee case, and the condemning authority and the client can always do what they did in Wynn. They can terminate the lawyer on the eve of trial, take advantage of all of his work, in this case 4 years of work, 711 hours of attorney time, terminate the lawyer, and cut a deal between themselves. Additionally, it becomes apparent to the client as the case goes on that he can get a much better deal from FDOT if he eliminates the attorney's fee. And the attorney's fees, of course, in this case, are constitutional. Florida is not a just compensation state. The Constitution says full compensation. And the Florida Supreme Court, we filed a supplemental notice of authority, but the attorney's fees in an eminent domain case are part of just compensation. They're part of the Fifth Amendment, and they're part of the Constitution. So the short answer is that is a common clause. Another common clause is a cooperation clause, that the client can't terminate the client or terminate the contract without being responsible. That's the holding in Wynn. Wynn, the Florida Supreme Court in Wynn versus Cocoa Beach held that if the client terminates the lawyer and settles on the side and doesn't pursue the attorney's fee, the client becomes liable for those fees.
Did the client, in your case, ever express the desire to terminate your services?
Yes.
When, more or less, when in this situation did they do that?
Generally the spring of 2018, after almost 4 years of representation, 3.5, 4 years, but they did it by a repudiation letter. Mr. Pettit, their attorney, sent me 2 letters, one on May 18th, 2018, and one on May 21st, 2018. It was shocking to see a lawyer put in writing a threat that he was going to file a bar complaint unless I agreed to give up my 2 fee agreements. And I had an eminent domain fee agreement and then a subsequent hourly fee agreement. The letters Mr. Pettit, on behalf of the client, sent, and the client signed an authorization with that, sought to extort me to sign a 1-page illegal fee agreement. Now, backing it up here, I can't sign an illegal fee agreement, a 1-page illegal fee agreement that says I cannot talk to the court, I cannot talk to opposing counsel, and I cannot talk to the client.
Let me ask you this. Have you gotten a fee for services related to the condemnation?
No, I haven't been paid anything.
Never gotten anything from anybody?
Not a dime. In fact, last year I made $15,000, Judge. I've spent enormous amounts of time and resource on this case. The client in this case hatched a scheme to eliminate the attorney's fees. Those extortion letters that their lawyers sent, May 18th, they're in the record, May 18th and May 21st, they say your fee agreement's illegal. They say that it violates Rule 4-1.5, and then they cite to a case which is an attorney's termination clause in a personal injury case where the termination clause contained liquidated damages and a penalty. My fee agreement doesn't contain any penalty. It doesn't contain any liquidated damages. It just says the quantum merit standard, reasonable value of attorney services, which is exactly what the Supreme Court's phrase was in Wynn and in Rosenberg. How is that a penalty provision? And the reasonable value of the services could be a big fat zero. Our contracts, all of our contracts with this client, these 2 contracts I'm talking about, the eminent domain contract and the hourly fee agreement that the client subsequently entered into, those were the 9th and 10th fee agreements signed by Mr. Taylor. Every single one, contrary to what the referee found, there wasn't a new provision regarding interpretation of ambiguities. It's in all of those previous 8 fee agreements which are in the record. You have extremely sophisticated clients, developer clients. I'd represented Mr. Taylor for 4 or 5 years. He signed a total of 10 fee agreements with me. Each one said that ambiguities would be construed, that the contract would be construed equally between the parties. Every one of them. So that provision wasn't new. The referee said it was new. That's not correct. It's erroneous. He said that the second hourly fee agreement didn't apply, even though that the second hourly fee agreement says for each additional hour of work, the attorney would be paid the princely sum of $395 an hour. That is well below the hourly rates in Tampa. That's not an unreasonable fee. The constitutional provisions are relevant. They're going to play out, I'm afraid. But the First Amendment is activated by commercial free speech. There's an allegation that Aloyma Sanchez made that I threatened her with a lawsuit if she interfered with the contract. I did do that. I told her that I would file a lawsuit against her if she interfered and violated Florida law, which also would have violated a court order at that time. I did warn her of that. One of the elements of interference is notice to the other side. Before I go any further, I'd like to leave about 3 or 4 minutes to 4 minutes, say, of my time for rebuttal. She then asserted, after a hearing where she had disparaged the expert witness who was not present, it was unsolicited disparagement of his fees in front of the court, and under the rules, I'm supposed to encourage her not to do that. It's not fair to someone who's not there, not represented, and is attacked on his fees, which are very important to these experts. They depend on getting paid as much as lawyers do, even more, I think. She then asserted that I had threatened to file a bar complaint against her. In this case, it's her word against mine. She has pointed to, she brought a witness with her who prepared the original Hobby memo. She produced an altered, fabricated document for 4 years. She shopped it during the arbitration. On the eve of the arbitration, she sent it to us by an email claiming she had just discovered it. On the 7th day of the bar trial, Mr. Hobby comes into court and he's got his original Hobby memo. Nowhere does it mention Florida bar complaint. Compare that to Aloyma Sanchez's memo, and she stuck in there the words Florida bar complaint. That's fabrication of evidence. We filed on the we got this notice on the 7th day of the bar trial. After 4 years, we've been told what this memo is. We objected to it. We objected to the whole process at that point. We asked the court to schedule a show cause hearing. One lawyer stood up and opposed that, the Florida Bar Council. They did not want to have a hearing on to how it was that Sanchez had been shopping these two, and the counsel for the FDOT had filed an affidavit in the Florida bar case saying he'd produced all drafts plus all the metadata. We introduced into evidence metadata showing that the Hobby memo had been modified 5 times in a 1-month period, as late as August 16th, 2018. It was dated July 19th, 2018. You have absolute evidence of fraud by the FDOT. They didn't produce this document to us until the 7th day of a trial, 4 years after the charges were made. The referee didn't care. He said, "No problem, no problem. You're not prejudiced, and we're not going to do a show cause here, and we're not going to get into that." Make it simple, perhaps. There are several objectively lawful instruments. The 2014 eminent domain fee agreement is clear and unambiguous. The contract says, as set forth in this agreement, because I don't think I answered your question. It says, the first line is, as set forth in this agreement. That means you have to read the whole agreement. What the Florida Bar and the client have said is, oh no, we only have to read the first paragraph. That's the only thing we have to look at. If you look at subsequent paragraphs, we warn the client about the proposal for settlement statute, the offer of judgment statute. In those cases, the client can be liable for fees to the FDOT, and he can be liable, it says, if you don't accept an offer of judgment and we go to trial, then you have to pay our fees. There's nothing wrong with that provision, and there's nothing wrong with telling a client what the risks are, what the dangers are. Eminent domain practice is extremely complicated. The referee in this case said, if they had read the contract, because they didn't read the contract allegedly, if they'd read it, they wouldn't have understood it. That's not the standard. It's an objective standard. Can this court, when it reads the eminent domain contract, the 2014 contract, the fee agreement, and the 2018 fee agreement, can you understand it? It's an objective standard.
Counsel, could I get you to address an assertion by the other side that in the eminent domain case that the client wanted to achieve a settlement very quickly, but instead you filed unauthorized pleadings contrary to that and allegedly in your own interest? Could you address that?
Sure. The client wanted a settlement promptly. If you look at the April 12th meeting agenda authored by Jack Suarez, he said he wanted a prompt settlement within 13 days. That was later extended to early May and mid-May. because the contract kept getting extensions. I think that eventually they had 10 extensions. He wanted a quick settlement. But if you go back to that agenda, Suarez agenda, he said what was holding up the sale and the closing were engineering changes. They wanted a settlement where they wanted an existing 7-acre pond, not a small structure, plus easements, plus drainage structures, ditches, pipes, all sorts of things that are part of the order taking. As part of the settlement they wanted their lawyer to convince FDOT to move all that pond, the structures, the easements, 200, 300 feet eastward to create 14 waterfront projects. They wanted a quick settlement, but they had always wanted to move the pond so they would have a wider opening, a more attractive opening, and they wanted those 14 waterfront lots. That was the marching sign. They leave that out. The client very cleverly says, oh, we wanted a settlement agreement. Mr. Rush wouldn't try to get the settlement agreement. In my practice, when you're dealing with difficult opposing parties like FDOT can be and large corporations can be, you have to demonstrate leverage so that they will come to a settlement. The client directed us to pursue an aggressive settlement posture, set the case for trial, put pressure on them. There are memos from Jack Suarez, emails saying, set the case for trial so we can hold it over their head. That's a March 27, 2018 email. There's a March 27, 2018 email, same date by Mr. Taylor, the managing partner, saying, you got to tell them how much this is going to cost them if they don't move everything. That's what we did, and we did it through motion practice, which is how trial lawyers begin to notify the other side of the dangers they're facing. The pond that's attached to.
So you're saying your motions were consistent and pursuant to your client's instructions, not in conflict?
I agree with that, yes, sir. They were impliedly authorized. But they're also part of the fee agreement. The fee agreement also discusses restoring access. That was one of the things we did. But there's an unbroken demand by the client from 2017, early 2017, until they settled without me in December of 2018, almost 2 years, unbroken effort to move the pond to restore access. Those motions were directed towards the idea that this was going to cause enormous severance damages. Our appraiser said $5.6 million. That's the number FDOT put in their settlement approval justification. This is a statutory required document. It's in the record. FDOT themselves recognized the damage, the severance damages of $5.6 million. In addition to that, we had land taken of 9 acres. This is not a small taking. It's a 400-acre development, 1,200 units, and they've taken all of the uplands, which are surrounded by wetlands. They've taken all of the uplands so they can build a retention pond. You can't build a retention pond in wetlands. It won't hold any water. So you have to go to uplands and dig it there. When they did that, they took our access to Sam Allen Road. Now, they didn't destroy it all. They left us what was about 30 feet. They reduced it from 110 feet to 30 feet from our plans.
Counsel, I'm sorry to interrupt you. You're down to under 3 minutes, just
Okay.
letting you know.
Thank you, Honor.
Thank you, Mr. Chief Justice, and may it please the court. My name is Tiffany Roddenberry, and I represent the Florida Bar. While there is no question that an attorney has a right to seek payment for their work, Mr. Rush's overzealous pursuit of his fees crossed the line in numerous respects. Mr. Rush engaged in a course of conduct that was designed to maximize his fee award, and he pursued payment of those fees without concern for the interests and objectives of his client. Because the referee's recommendations of guilt are supported by competent substantial evidence, and because the referee's recommendation is supported by the sanction standards in this court's case law, the Florida Bar asks the court to impose the recommended sanction of a 3-year suspension.
Counsel, could I have you perhaps summarize what evidence supported the referee's finding that Mr. Rush took actions against the direct instructions of his client? Because it seems to me like if there is competent and substantial evidence in the record that that in fact was the case, that's an important consideration for this court.
Yes, Your Honor, there were a number of actions. So beginning in the spring of 2018, the client's objectives changed where they wanted to get to a quick settlement. So at that point, they began taking actions, including directing Mr. Rush to begin trying to settle as opposed to pursuing certain non-monetary benefits. So when they brought in co-counsel, Mr. Pettit, at that point, Mr. Pettit there was growing concerns that Mr. Rush appeared preoccupied with gaining certain attorney's fees. So Mr. Pettit directed him to, for example, withdraw certain motions that were not in line with what the client wanted. Mr. Rush withdrew those motions, but not long after, again filed renewed motions that essentially made the same arguments. Mr. Rush, without his client's knowledge or consent, sent a settlement offer on May 4th, 2018 to FDOT. Within that settlement offer, he said that the clients were at that point willing to waive a substantial monetary benefit, which would in turn produce a non-monetary benefit on which he would earn fees. And then later, in late June 2018, when Mr. Pettit, on behalf of the clients, directed Mr. Rush to send a certain settlement offer to FDOT, Mr. Rush took it upon himself to change that settlement offer to preserve in his mind, to preserve his right to certain attorney's fees. Justice Curiel, you mentioned earlier, what is the applicable standard? And just to clarify, Mr. Rush continues to look to the standard of review that applied below, which was the clear and convincing evidence standard. But now he is before this court seeking review of the report of the referee. And now the standard is there evidence? He must show that there's no evidence in the record to support the referee's findings, or that the record clearly contradicts, and he cannot do that. First, the referee appropriately found that Mr. Rush violated Rule 4-1.5. This court has made clear in cases like Florida Bar versus Doe that a fee agreement containing a penalty provision runs afoul of the rule when the effect is to intimidate a client into not terminating their attorney's representation and to penalize that right. Here, Mr. Rush's 2014 representation agreement confusingly said both that he would look to only the condemning authority for his fees, but in the termination provision it said that should North Park elect to terminate, they would be responsible for the reasonable value of his services. Mr. Rush used that confusion and ambiguity to intimidate his clients into not terminating the representation agreement when they otherwise would have. Specifically, at the April 12, 2018 meeting with North Park, Mr. Rush at that time indicated that if his clients did not pursue the course of conduct that he wanted them to pursue, which would preserve his right to attorney's fees based on non-monetary benefits, that they could be on the hook for his fees, which he could only estimate at that point would be $300,000 to $1 million in legal fees. Mr. Rush's rough estimate at that point bears little relation to potentially the quantum merit value of his services, and it appears that that estimate was based on him achieving the non-monetary benefits that he wanted to achieve on behalf of the client. Notably, when the parties did settle the eminent domain case, the record shows, I believe in the testimony of Mr. Pettit and Mr. Rush himself, that the resulting attorney's fee based on the benefits achieved was around $110,000. And I can't speak to whether Mr. Rush was actually paid, Justice Kennedy, but the stipulated final judgment resulting from the attorney fee litigation that's in the record indicates that North Park ultimately agreed to an attorney's fee of around $115,000. As North Park's managing member, Jack Suarez credibly testified he was intimidated by what Mr. Rush's interpretation of the agreement. And he was concerned that if North Park did not settle in the way that Mr. Rush wanted it to, that they would be on the hook for potentially millions in dollars in legal fees, including when Mr. Suarez indicated the same at the May 24th, 2018 hearing in front of Judge Thomas, where he said before the judge that he was concerned that he was unsure what to do about Mr. Rush's representation because of the threat of fee liability.
Let me go back to where you said he made the threat to sue for attorney's fees based upon what he was certain valuations of the property and pursue a non-monetary course of action. As a matter of substantive law for eminent domain lawyers, if a client has two possible courses of avenue to pursue, perhaps with settlement with DOT, may an eminent domain lawyer make a claim for the higher valuation, even if a client chooses to go an alternative path?
No, Your Honor, I think that would be the decision of the client as to what, whether to pursue additional benefits.
And then the lawyer is essentially stuck with whatever choice they make so far as their course of action.
Yes, Your Honor. Under the eminent domain statute, it would be his, at least under subsection 1, in general cases, his fee would be based on the benefits achieved for the client. I think the client does have the ability to decide what benefits to pursue.
The benefits achieved, not the benefits that possibly could have been achieved.
That's right, Your Honor. Mr. Rush also tries to confuse things by pointing to his 2018 hourly fee agreement with North Park, but I think the record is clear that that agreement was limited to the preparation of a memorandum of understanding. It did not supplant his 2014 agreement under which he was asserting the right to attorney's fees, generally in the eminent domain case. The record also supports the finding that Mr. Rush violated Rule 4-3.4 by threatening his opposing counsel, Ms. Sanchez, with a bar complaint. The referee found that Ms. Sanchez credibly testified that after the July 18, 2018 hearing, he told her he would sue her for tortious interference, which Mr. Rush admits. But she also said, and the referee was entitled to credit her testimony, that he threatened a bar complaint. And he tied that threat to his ongoing pursuit of attorney's fees premised on the recovery of non-monetary benefits. Ms. Sanchez's testimony was enough to sustain the referee's finding, and Mr. Rush does not point to contradictory evidence that would undermine the referee's credibility determination. Mr. Rush again claims that his speech, to the extent he threatened her, it was protected, but this court has said in numerous cases that threats are not protected by the First Amendment, nor are baseless allegations. Mr. Rush again points to the Hobby Memorandum, which he says evidences there was fraud. To be clear, there is no evidence in the record that Ms. Sanchez falsified the Hobby Memorandum or anything else. What happened at the hearing was Mr. Hobby appears to have brought a different version to the final hearing, but Mr. Rush and his counsel had the opportunity to pursue additional action, including recalling Mr. Hobby to talk about and also issuing 2 subpoenas to FDOT custodians to investigate the issue. But at the final day of the hearing, his counsel said we were going to rely upon the fact that both versions of the memorandum were admitted into the record, as well as the fact that we have already elicited testimony from Mr. Hobby. The referee appropriately found that Mr. Rush's relentless and self-interested pursuit of his fees in contravention of the client's objectives violated the other rules charged in the complaint. As we discussed earlier, he filed motions that he had been directed to withdraw, and he repetitively filed motions asserting his right to fees at a time when he was not entitled to those fees as of yet. In addition, he made a settlement offer without his client's knowledge or approval, and that settlement offer was not revealed until later litigation. He also made a settlement offer that deviated from the express language he was directed to use, and to the extent he contends that he could not offer the exact settlement offer, I believe if you review the record, the settlement offer he was to send was a very simple document, and it contemplated the drafting of a stipulated final judgment that would have likely incorporated any language needed to preserve his right to fees. Just briefly, Your Honor, Your Honors, I want to speak to the sanction, which Mr. Rush did not speak to. The recommended suspension of 3 years is supported by the standards, and it has a reasonable basis in existing case law. The referee cited a number of cases that support an imposition of that suspension, including Florida Bar versus Comite, Florida Bar versus Scott, and Florida Bar versus Peterson. In Comite in particular, the respondent was found guilty of a number of rule violations, including, much like Mr. Rush, violations of 4-3.1, 4-3.4, and 4-8.4D. And the court said that while each individual violation standing alone might have justified a lesser suspension, the cumulative nature of the misconduct required the lengthiest suspension the court could order, which was a 3-year suspension.
How would you compare the harm to the client in this case to the harm to the client in those 3?
Your Honor, the harm to the client in this case included the fact that they were delayed in resolving the eminent domain litigation. In Comite, it was more the harm. It was less harm to the actual client. In that case, it involved an attorney who was continuing to pursue attorney's fees, and it was actually harm to the opposing party who was pursuing the right to get fees, and then the respondent in Comite actually wrote to the assistant U.S. attorney and tried to get the opposing party criminally charged. So regardless, I think the harm to the client here was that their case was settled. I mean, their case was delayed. They also had to incur costs through their co-counsel or their additional counsel, Mr. Pettit, who they had to bring in to try to bring this into a landing.
Can I ask you a question about the cumulative stuff with the sanctions? Because I know our cases talk about that concept a lot. And I understand the idea of the cumulative misconduct when you have different victims or, a past case or something like that. But it seems like it's also gets applied in cases where you essentially have this kind of hodgepodge of bar rules that are kind of overlapping, and seems like there's a lot of discretion in terms of which you could charge, and the same conduct basically will be said to have violated several different rules, and then that gets described as cumulative, which then justifies a harsher punishment. I'm just curious how you think the court should think about the concept of the cumulative issue in terms of, what is appropriate to sort of treat it, or should we be asking about, distinct enough conduct, or should we be looking at just counting up the number of bar rules violated, or how should we be thinking about that?
Your Honor, I think it probably depends on the case. I don't know that it would be counting up the bar rules, but here it was one pursuit of attorney's fees, but it culminated in various actions that harm both the client, including their need to file additional counsel to get this case settled, and they had to, deal with numerous filings, including the Liz pendants that tied up their property. It also involved the separate conduct of Mr. Rush threatening his opposing counsel with a bar sanction. So I think cumulative here means that there were various actions. At every turn, he made things worse rather than better. And so those factors can be considered in deciding whether or not he is worthy of a 3-year suspension.
You mentioned that part of the harm is that Mr. Rush caused his clients to hire another lawyer to, like you said, bring this to a landing. Was the eminent domain case ultimately resolved by the new client, the new lawyer?
Yes, it was. It was resolved in late 2018.
Okay, and were the clients able to sell the property they were interested in selling?
Yes, Your Honor, to my knowledge, they were able to sell.
So from a monetary standpoint, there was no harm to the clients?
Other than having to pay additional counsel.
That's a different matter, but as far as the deal is concerned, there was no harm to the clients.
I think that's true, Your Honor.
So basically they had to hire another lawyer to come in, pay his or her fees to bring in, basically resolve the case.
Right, and they did have to face a separate lawsuit by Mr. Rush, which raised a number of claims that also involved fees for going through that arbitration, in addition to the fees they had to incur to dissolve the list pendants that was placed on the property.
Did Mr. Rush establish a lien for his attorney's fees in the case?
I believe he did. He filed numerous liens, and certainly we're not contending that he could not file an attorney's fee lien, but it is the bar's position that his Liz pendants, which tied up the broader North Park property in a separate lawsuit for fees, was improper and frivolous under the law. Consistent with the referee's findings, including on the aggravators, which Mr. Rush does not contest, Mr. Rush has insisted on portraying himself as the victim of a scheme to defraud him of fees, based on a theory of benefits his clients no longer wanted to pursue, and that he ultimately never achieved on behalf of his clients. This court's case law, including Comite, Scott, and Peterson, all support imposition of a 3-year suspension based on Mr. Rush's pattern of self-interested and unprofessional conduct. And for all those reasons, we ask the court to impose the recommended sanction. There are no further questions. Thank you.
I'll try to be brief. That's a bunch of baloney, and the client never changed their goal of moving that pond. As late as October 15th, 2018, 6 weeks before they settled the case, they were demanding that FDOT move that pond. The non-monetary benefits, it seems to be confusion about that. The non-monetary benefit is the flip side of severance damages. The appraiser said the severance damages from blocking access will cause $5.6 million in severance damages. If you do away with this by moving the pond, you will create non-monetary benefits and you will eliminate the severance damages. The severance damages at $5.6 million that's all part of eminent domain law. When you put a pond in the middle of the access road to a 1,200 unit development, you affect the value of the property dramatically. You affect access. I didn't seek non-monetary benefits. I sought to eliminate the severance damage, which triggered an attorney's fee that was 1/3 or less, probably a lot less.
Mr. Rush, were you authorized by the client to make the settlement offer you made on May 4th of 2014?
Yes. If you go back and look at the...
If you were, what is your argument that there was no competent, substantial evidence for the referee to disagree with you, as the referee did?
Well, because first of all, the North Park client, for 43 of the 44 months I represented them before I was repudiated, was Todd Taylor, not Jack Suarez. Most of this case is based on Jack Suarez's, I didn't understand the contract, I didn't know what was going on. Isn't it terrible what Mr. Rush did? I worked for Jack Suarez for 1 month, from April 18th to May 18th, when I got a termination letter saying that my fee agreements were illegal, and if I didn't withdraw them, I would get a bar grievance. The evidence is that the May 4th letter is substantively identical to letters sent on April 2nd, April 3rd, and then subsequently the same letters they sent. At trial, Mr. Pettit, my other friendly lawyer on the other side, he testified that Jack Suarez told us that he did not want any, he was not interested in it, and he was ready to waive, didn't care about any monetary compensation. That's fundamentally, first of all, that's an admission by the lawyer that we were told that Mr. Suarez, which we confirmed in a May 7th letter also, right after the May 4th letter, but the testimony at trial was the client no longer wanted the compensation. That compensation had been pegged by Mr. Taylor, the managing agent for 3.5 years, at $2.84 million. He sent us an offering, an appraisal on not appraisal, but an offering on a separate piece of property. Mr. Suarez was willing to trade all of the compensation for the 9 acres taken. In an eminent domain, there's land taken, and there is severance damages. Those are the big numbers. Mr. Suarez was willing to give up the claim for compensation for the property taken in order to get what are called the non-monetary benefits. I didn't come up with the non-monetary benefits.
Counsel, I'm sorry to interrupt you. You can have 30 seconds to wrap up.
I'll talk about the one issue. Aloyma Sanchez's testimony by herself that she heard me threaten her with a bar complaint is not clear and convincing evidence. If that's the case, then any lawyer in this state can be accused by one other lawyer of doing something that they heard, and that's sufficient. In this case, there is no question that the original Hobby memo that he brought on the 7th day of trial does not mention the words Florida bar complaint, and Aloyma Sanchez shopped at a modified memorandum that specifically added the words Florida bar complaint.
What happened in your 2 lawsuits for fees?
The court, we were directed to go to arbitration, and the arbitrator split the fee 80-20. The lawyer who'd done 4 years of work on the appraisals got 20%. the lawyer who, quote, landed it and kept asking for the same things we did, he represented the client for about 5 months. She gave him 80%.
What did you get?
I was awarded 20%, but I had to give that up.
Okay.
I had to give it up in order to get rid of that case.
All right.
I've never been paid anything in this case.
All right.
Thank you.